So last week, the federal government changed the definition of harm. In fact, they didn't just change it, they removed the definition of harm. And in the world of the Endangered Species Act, that's a pretty big deal. So originally, when the Endangered Species Act was passed by Congress and signed into law, it basically prohibited what they call take. That's to kill an animal, trap an animal, otherwise harm or harass an animal. And that word harm was part of the definition of take. Then in 1975, Fish and Wildlife came out with a regulation that further defined harm. And what's really important for my industry, conservation banking, is that harm at that point in time meant to modify habitat in some negative way. So that might be to completely remove habitat. In the case of lesser prairie chicken, it might be plowing up the ground, or it might be building a highway across the prairie, or it might be installing a solar array in the middle of the prairie. That would have been considered harm. But as of last week, they got rid of that definition. So now it falls to simple take. And what that means really is dead bodies on the prairie. So if you were to go in and plow out that prairie, build that solar array, build that highway, the bird is going to fly away. And that means that it's probably not going to die from that particular disturbance, but it doesn't have a home to go back to either. So now, under the strictest interpretation of the latest regulatory action, that means that there's not a dead body, there's not a take, which means conservation banking for lesser prairie chicken in a compliance perspective really no longer has a market. And we'll go into more detail on this as this podcast progresses. But that's it in a nutshell. For the last 50 years, Fish and Wildlife Service has regulated the modification of habitat under the Endangered Species Act. And what that really means is if you damage habitat, if you completely destroy the habitat, they've considered that incidental take. I know that's a technical term, but what it means is you didn't go out and actually kill an individual of the species. You don't have a dead body, but you basically destroyed their habitat. So they don't have a place that they can continue to thrive and maintain a viable population. So that's been the last 50 years. But there was a Supreme Court case fairly recently, last few years. It's called Loper Bright, and it effectively took away something that lawyers refer to as Chevron deference. And that really means that the agencies issuing regulations should be able to, within reason, interpret legislation to design those regs or those regulations. And that's called Chevron deference. So it may not be to the letter of the law as Congress wrote it, but it's within reason what the agency thinks is required in order to implement that law. So Chevron deference. So in that Loper Bright decision, this Supreme Court, which is fairly conservative, decided that Chevron deference has just gone too far, that regulations are now going way beyond the realm of what Congress intended on a law-by-law basis. So by striking Chevron deference down, they basically said to this administration and future administrations, you're really limited to what the law says explicitly when you're designing these regulations. So this administration took it upon themselves to look at various laws. In this case, the one that matters to our industry the most, of course, is the Endangered Species Act. So they looked at the Endangered Species Act and they looked at this definition of harm. And the definition of harm basically is not defined in the statute. It's defined in regulations. Then there was a regulation in 1975 that defined harm as habitat modification. Then in 1982, Congress came back and said, okay, since we now have a new definition of harm, we're going to modify or amend the Endangered Species Act to have to incorporate something called incidental take. So again, as the example, you knock out the habitat, but you don't kill the species. So that's incidental take because now the species doesn't have a place to go home. Think of it like I burn your house down, but you're not home, and you come home from the store, and it's in cinders, right? It's just a pile of ashes. So you can't really go back home. That's the same thing. So they call that incidental take. So Congress amended the act to incorporate an incidental take permit and to allow incidental take under Section 9 on certain conditions. But what they didn't do in 1982 is they didn't define harm. They just accommodated harm, but harm was external to the law. So now this administration looks at it and says, you know what? Those regulations defining harm, they actually are unauthorized. And so we're just going to get rid of them. And now, moving forward, we have a whole new scenario set up with, I think, a lot of uncertainty for sure, but definitely going to be complicated for compliance-driven offsets that are based in habitat. Let me give two scenarios, one of what it used to be like over the last 50 years, and one potentially what it's going to be like going forward under the new regulatory conditions. So over the last 50 years, if you were, say, a renewable energy company and you wanted to develop a solar array, let's just say that solar array is going to occupy 2,000 acres. You went out, you built the roads necessary through, let's say, lesser prairie chicken habitat, native prairie. You built the roads necessary, then you lay out panel after panel after panel after panel to make your array over those 2,000 acres. You probably would be looking at impacts that are protected habitat impacts, rather, for 2,000 acres worth of lesser prairie chicken habitat. Okay, that's the way it used to be. So you would then go and offset those 2,000 acres by purchasing conservation bank credits or some other means of mitigating those impacts. Now, today, the implications of what just happened last week would suggest that you build that same solar array, but as long as there aren't any dead prairie chickens laying around, you really don't have to have a permit and you don't have to offset those impacts going forward. So there's really no incentive to protect habitat going forward with the rescission of the harm definition, generally speaking. Now, there is a little uncertainty to that because on a species by species basis, on a Fish and Wildlife Office by Fish and Wildlife Office basis, they may decide that for a particular species, the habitat is disturbing the habitat does in fact mean take in some form or fashion of the species. But right now, where I sit today, I think that's pretty much an unlikely interpretation, but it is possible. So we'll just have to wait and see how it's implemented on the ground. For mobile species, right, those that would quickly evade danger, if the animal can get out of the way, then I just don't think Fish and Wildlife Service is going to say taking habitat is in fact take, because the chances of a dead body are slim to none. So what this rule could mean for conservation bank credits and really the demand for those credits. Traditionally, there were two avenues to sell a conservation bank credit in terms of Endangered Species Act compliance. Section 7, which is a consultation with the Fish and Wildlife Service and another federal agency that might be permitting a privately funded project, or it's working on its own federally authorized project. They consult with Fish and Wildlife Service. Fish and Wildlife Service takes a look at the footprint of the project. They would issue a biological opinion. That biological opinion is often based on some proposed mitigation strategy, which may include, especially in places like California, purchasing conservation bank credits. So that Section 7 route is still there. That is the government-to-government consultation pathway. There's still an opportunity to sell credits in that particular avenue. But to be frank, outside of California, Section 7 conservation bank credit deals are fairly rare, again, outside of California. So majority of the country, though, we have done conservation banking deals under what's called Section 10, and that's the incidental take section. That's where incidental take permits are authorized. So again, if you destroy habitat, but it doesn't end up with dead bodies before the last week, over the last 50 years leading up to last week, that would have meant you would go to a Section 10 permit. Those are usually habitat conservation plans, HCPs, of which we actually have two. Or it could be CCAAs, CCAs, and those are acronyms. Don't really need to worry about it. Just know that those also allow under Section 10 for the destruction of habitat, as long as you replace that habitat in some form or fashion nearby. So that is the section. Those Section 10 and still take permits, I think they're effectively off the table moving forward. And the existing Section 10 permits that are out there, this rule potentially will lead to abandoned HCPs, abandoned CCAAs. I'm not saying that's exactly what's going to happen. I'm just saying that's a potential outcome. And so I just don't see the immediate incentive for anyone to participate in those HCPs and those CCAAs anymore, because the federal government now appears not to consider habitat loss as take. And that's, largely where our conservation bank credits were sold, was through those Section 10 permits, those incidental take permits. So I'm afraid that could be over. These are voluntary markets, so anyone can participate. It's not like buying a conservation bank credit is illegal, and it's not like joining a habitat conservation plan is illegal. There's still options on the table. They just aren't going to be required for compliance purposes. So, in my experience, we have done voluntary deals and we've done compliance deals. I can tell you that when there's a compliance driver, more deals get done and each deal tends to be bigger. When there's not a compliance driver, then voluntary deals can happen. They're just few and far between, and the scale of each deal is considerably smaller. This effectively moves the regulatory front when it comes to species out of the federal jurisdiction and into state jurisdiction. And so we've seen states like Colorado begin to start thinking about this. We've seen states like California with a long track record of protecting species at the state level that aren't protected at the federal level. So in the context of this change, what's likely to happen in California are all the federally protected species that are dependent on habitat, they are going to effectively be listed under the state law. So I think what's happening in California was they sort of picked, they were judicious with their energy, and they said, okay, we'll take jurisdiction over what the feds don't. And now they're going to have to say, even though it's on the federal list, because this rule has been rescinded and habitat is effectively no longer protected, then they're going to have to list those species within their own state statutes. So I think that's going to happen in California most likely. Colorado is just starting to flirt with this idea on the lesser prairie chicken. We're told that next session there's going to be a bill that will effectively that would effectively be introduced in order to protect the chicken and require offsets for habitat losses. So that'll be a new frontier for Colorado, because they don't actually have a take provision on the books at all in Colorado. They do have species that are on their list, but all that really means in Colorado is that it prioritizes conservation investments that the state makes. And that's a broad generalization, but effectively that's what it does. So this new law that we anticipate being proposed in the next session next year would be a dramatic departure away from the way that they typically would list species, and it will go a very different direction. I think that a lot of blue states are going to start looking at this and thinking, okay, maybe they have to come up with their own programs. And this is effectively what has been done because of dramatic changes under the Clean Water Act and how the federal government has managed jurisdiction there over the last several years. For those of you not familiar, there's something called Waters of the U.S. It's a bit analogous to this in the sense that Waters of the U.S. just really means exactly that, where federal jurisdiction is and isn't when it comes to waters across our nation. And so, quick history on that. In 2015, Obama's administration issued a more expansive definition of what waters of the U.S. is. It inspired a lot of pushback. Then in 2016, after Trump was elected, he ran on a platform, believe it or not, in front of agricultural communities that he was going to roll back WOTUS expansion. And he did in 2020. And then Biden came in 2021 and effectively added back in those protections that Obama had with some changes. So we saw Obama expand jurisdiction. We saw Trump dial it back. We saw Biden dial it back up. And then Trump has already proposed to dial it back again. So a bit of a seesaw, a regulatory seesaw with each new president. And potentially that's where we're going with this rule, this harm definition. There are a bunch of challenges on the landscape right now in terms of environmental NGOs, and I'm told that some attorneys general from several blue states intend to file suit as well. So that's going to have to work through the courts. If it doesn't get to the Supreme Court between now and the next election, and the next president comes in, the next president could actually, assuming it's a Democrat, they could reinstitute the definition of harm. And so we just have a yo-yo again. Now, eventually this will get to the Supreme Court because there will be challenges. Right now, there are challenges from the left. If you have a Democrat step into the White House, reinstate that rule, you'll have challenges from the right. So one of these sets of challenges is going to make it to the Supreme Court, and they're going to make their decision as to whether or not this is the truest reading of the statute. And in the interim, Congress could actually do its job and re-legislate this issue and provide its own definition of harm. But there's no telling if that'll happen, when that'll happen. Not trying to prognosticate or even pass judgment on whether this is the best reading of the statute, because I'm a pragmatist. I'm not an attorney. And so I don't really know if this is the best reading of the statute. It may be. And if we assume that it is, and that harm is not going to be defined by Congress at some point in the future, what does that mean for conservation banking? What does that mean for species? So we have a rough estimate that 92% of the listed vertebrates, those are, animals with backbones, are dependent on habitat, and they're listed because their habitat is limited. In other words, if we don't protect the habitat, they will continue to suffer losses. And eventually we'll reach the point of jeopardy or extinction. And by jeopardy, that's a legal term that means that the next step really is extinction for them. And that has some consequences in the ESA. But we're going to have to find a way to, if we want to get the species off the list, we want to help these species recover, which I think is the clear intent of the Endangered Species Act, despite all of its flaws, that appears to be the intent of the act. If we're going to help these species recover, we're going to have to find a way to incentivize investment in habitat for those species so they have a place to succeed, to thrive, to build their populations back to levels that would allow us to delist them, and basically make sure there's no threat of regulation in the future. So yeah, the biology itself is not controlled by this rule, but the compliance mechanisms certainly are. So would love to find a way that we can make that work, where we can continue to make these investments like our industry has made. And recent estimates on what the conservation banking investments on the landscape today, we're talking hundreds of millions of dollars currently. And that is not insignificant. And we're talking, hundreds of thousands of acres historically have been invested and have been built into these conservation banks. So I think the total estimate of investment to date, that includes all the conservation banks on the ground, all the credits sold, plus existing investments to maintain existing inventories, we're approaching $500 million and probably north of that. So it's a pretty significant investment. So if we're going to use those investments in meaningful ways, then I think we have to be a little bit more creative. It's not going to be the status quo that we've had over the last 50 years of, industry takes an acre of habitat, they go buy an acre plus of habitat. We're going to have to do something different. And, within the Endangered Species Act, there is Section 7A1, which requires agencies to make investments in programs to help listed species recover. There's also additional sections. I think Section 5 is where Fish and Wildlife can directly invest in habitat. A lot of that, I believe, is tied up in land acquisition. So that comes with its own controversial issues, right? The federal land grab issues, which in my particular territory of the Southern Great Plains, which predominantly these are agricultural economies, these communities are not always, but they typically vote Republican. They don't look kindly on federal land acquisition. In fact, there was one in particular in West Texas that was finally beat down by Senator Cornyn and Senator Cruz here in Texas. And it was proposed under the Biden administration and withdrawn by the Trump administration. So Section 5, at least in the red parts of the country, I don't see that being very helpful. But maybe Section 7A1 is somewhere where we could lean into, and someplace that Congress could rather uncontroversially suggest that, not suggest, actually require and appropriate monies for recovery credit purchases. And that's something we've talked about before, right? And that's the idea of using Fish and Wildlife standards for permanent conservation, that's outcome-based types of crediting, and have the government purchase those credits as recovery credits to fulfill their obligations under 7A1. And then keep in mind that all these species that are habitat limited, they're going to continue to make the endangered species list. And, I just paraphrased, excuse me, let me back that up. I just summarized all the uncertainty in terms of court decisions, the uncertainties in terms of the next administration and what they may or may not do. But, this is not a foregone conclusion that this is the best reading of the statute as represented by the rule that was published last week, right? So we could find ourselves putting more and more species on the list and then realizing that actually this administration got the best reading of the statute wrong, and that losing habitat is actually harm. And then we're in a bad way where we're regulating this big energy build out that we have right now, after people have made investments assuming that they can just plow through habitat without having to comply. So there's the potential that this could be a snag more than it is actually a gift from the administration. Time will tell. Regulated industry is going to watch this very carefully, and they're going to track all the court cases, not just track the outcomes, but track the pace of the court cases. So I'll give you an example. Recently, there was the God Squad decision that came out of the Gulf of America or the Gulf of Mexico, whatever your preference is. Defense Secretary Hegseth basically said that we're not going to deal with the Endangered Species Act for the species because oil out of the Gulf is a national security issue. And so they set up a God Squad, which we probably could have our own little segment on that. And maybe I'll put a pin in it for now and we'll come back to that. But effectively, they just decided they don't have to list the species. They don't have to basically comply with any sort of conservation or avoidance provisions of the Endangered Species Act when it came to the species. So it's gone. And the reason why they call it God Squad is because effectively this room full of cabinet members have assigned the species to extinction. I mean, that's why we call it God Squad. So they get to decide whether the species exists or doesn't moving forward. So that was immediately challenged by the environmental NGOs. Typically, when you file a challenge, when environmental NGOs file a challenge against the government really moves slowly. And they will, they move and they defend their decisions usually, but it's really not in any immediate sort of urgency that they do. That appears to be a different approach than this administration took when it came to the God Squad challenges. They very quickly moved and they jockeyed for venue. Really what that means is, anytime these environmental interests file suit, they like to pick the venue. They like to pick the court that's most likely to give them the outcome they want. And the federal government has the right to basically object to that. And there's jockeying back and forth on venue after that. Well, the administration was successful getting venue inside the Fifth Circuit of Appeals. And the reason why that's significant is that that's a conservative appeal circuit, and it happens to be the appeal circuit with that sends the most Supreme Court cases on up, right? Or let me rephrase that. Happens to be the circuit that decides cases that the Supreme Court picks up more than any other circuit. So obviously, if they think they're going to get a favorable decision out of this Supreme Court, they wanted that venue and they got it. So I think that what industry is going to do is they're not only going to look for the outcome of these challenges to the most recent rule change. They're going to look at how the federal government is responding. And if the federal government is responding quickly and aggressively, then I think they're successful in getting a venue that might be, say, like the Fifth Circuit, then I think their calculus is going to be, this is a low risk for us, build, build, build. If, however, there's suddenly an injunction or the venue, as the government slow rolls it and the venue is really favorable, they may have a different risk assessment and decide, you know what, let's hedge our bets a little bit. Let's be ready to mitigate if we have to mitigate. So I think it's a wait and see approach for industry. And then if there is a Section 7 consultation that pops up, because industry does need to go through certain federal processes to tie into the grid, to build power, there may be a Section 7 consultation they can't avoid. And the service may then decide, hey, look, habitat is really important for a particular species, and your project may jeopardize this species. And that's that jeopardy term we talked about earlier. If they decide there's jeopardy under a Section 7 consultation, it'll have consequences for the build out of whatever that development is. That could be a reroute. It could be significant compensation in form of conservation somewhere else. It could be a no-build scenario. So that's all up in the air. In terms of the Prairie, I think that this decision is unfortunate, at least in terms of how industry will look at their layouts, their routes, their plans for development. It really does take away a regulatory hammer, if you will, from their calculations. And we already know that prairie is the least valuable land use in the Southern Great Plains. Just native rangeland is worth this. Plowed ground without water is worth this. Plowed ground with water is probably worth this. So, and then of course you put wind towers on it, it's here. You put solar arrays on it, it's here, right? So it really just drives home and reinforces the reality that rangeland, native range, native prairie is the least valuable land out on the Southern Great Plains. So it makes sense. If I were an energy developer, that's exactly what I'd be looking for, because my land costs would be lower. So I don't think it's good news for the chicken in terms of how we viewed these compliance markets over the last 50 years. Now, I think that there's reason for hope, and I think that there are other things that this administration is considering, and we are working actively with the administration, hoping to get them there, that, hey, look, given the uncertainty with, number one, the listing for the Western Prairie chicken, on the list, off the list, on the list, off the list, and we're in the midst of another listing decision now, and given the 50-year history of regulating habitat and how important that habitat is for our energy build out, but more importantly, how important it is for the successful recovery of the species. If this interpretation, the truest reading of statute, and the removal of the harm definition doesn't stick, and the bird ends up on the list, we could be in a really bad way, and we could have yet another complication going forward for the energy build out across the Southern Great Plains. So this administration is seriously considering an approach that would leverage existing programs with existing appropriated dollars to target recovery credit purchases across the Southern Great Plains for the lesser prairie chicken. And that would provide the conservation that the Fish and Wildlife Service needs in order to reach a decision not to list a bird. In other words, reaching a decision that, hey, look, enough of a conservation investment has been made on the landscape that we're not worried about the future of this bird anymore. It should have enough habitat to maintain a viable population going forward. So that is what we've talked about in the past as the 250 for 250. I think it might be more appropriate that we rebrand that to the grand bargain, because that's really what it is, which is it's the grand bargain where we can find common ground for working lands, that is adding real value to native range, making it sensible to hold on to that native prairie as opposed to converting it to ag or selling lease rights for energy development. So that's a win for working lands. It's a win for energy development, because if all this uncertainty shifts in a very particular way, compliance is going to be expensive and complicated. And then it's a win for wildlife, not just the prairie chicken, but it's a win for all the other wildlife that comes along with it. Because as we all know, the chicken really needs healthy prairie. And healthy prairie is exactly what the deer need, the antelope need, all the prairie birds need, all the wildlife, elk, you name it, they need it. And so pheasant and quail included. In terms of the grand bargain and why our stakeholders should care, but at the state level, this does give the opportunity for states to weigh in on where those investments actually take place. And I think that that's what's been most exciting for me, is engaging state by state by state across the range. There's 5 states, right? Texas, New Mexico, Oklahoma, Kansas, and Colorado. And each state really has its own suite of priorities and its own ideas on where conservation should be and what it should look like. Now, Fish and Wildlife Service is the ultimate authority if we're looking at limiting federal jurisdiction. They really need to be comfortable that this conservation is to the right standards and in the right location. But within that very broad envelope, the states seem to be starting to think about where they would prefer to site these conservation projects and how they would like them organized and what other priorities they might meet for the state themselves. So they seem really excited about it. And they also, obviously, especially in the West, are excited about having the feds not tell them how to regulate their own resources. So there are incentives for federal government, there are incentives for state government. When it comes to the energy developers, we need to make it easier for them to build out this energy build out, the grid build out, provide all the generation that's needed so that we can have affordable energy rates, we can have a reliable grid, and they really shouldn't have to deal with complicated, open-ended permitting timelines that's very difficult for them to actually plan around. In fact, there was an article in today's Wall Street Journal talking about how energy rates have gone up 4% year over year, and new construction for new generation has gone up 10% year over year. So at those rates, every month that there's a permitting delay, every year that permitting delay gets extended, it just means that at the end of the day, the ratepayers are going to have to pay more. So we got to make it easier in order for that build out to happen efficiently and affordably. And then, of course, there's the landowners, the ranchers, and even the farmers that may be thinking it's time to hang up the plow. If you hang up the plow, it's time to put up the plow, and maybe convert some of our dry land back over to native range. So this gives them a new value for intact prairie. It basically provides a decent price point, a market-based price point, for something that actually in the last several years really hasn't been worth a whole heck of a lot. One of the ranchers that we work with loves to say the following, that ranchers only make money off their ranch when they sell it. And of course, when they sell it, it usually doesn't stay as range. It's usually converted or it's subdivided or something else. We typically tend to lose it after it's sold. So we need to find ways to keep that native range intact, and we need to find ways to actually expand the available habitat for the lesser prairie chicken and all the other associated wildlife that goes with it. And then, of course, the conservation community, if we build out the grand bargain like we think maybe it would be built out, we're talking hundreds of thousands of acres. That gives the conservation community a new lifeline. I think a lot of the land trusts out there have been working under the old conservation easements for tax credit model that has become less and less easy for them to work with. Effectively, that the people that are holding on to this range may or may not actually be able to use the tax credits, so they're certainly not signing up for them. But Congress also has limited the capacity and the value of those tax credits over time, as they should have. There was some exploitation of loopholes there, so they've tightened it up. So the old tax credit model for conservation really isn't delivering the gains that the bird is going to need on the Southern Great Plains. So this could be a bit of a lifeline for those organizations and bring more conservation into their portfolios. Really, to close this out, yes, there's been a rule change. Yes, the potential of that rule change is that there's less of a compliance driver protecting habitat for all kinds of species, including the one that means the most to me and my family, which is the lesser prairie chicken. But that doesn't mean all is lost. And I am really encouraged by the engagement I've had with this administration in looking at innovative, disruptive ways in a positive sense for how we manage species listings in the 21st century. The way we used to do it really isn't fair. Quite frankly, by the time Fish and Wildlife showed up and decided that a species should be listed, the losses have already compounded. We've already suffered 1,000 cuts for that species in terms of its habitat and its chances of survival. So what that means is everybody before the listing just had a tragedy of the commons, right? A situation where they could use the habitat however they felt, and it didn't really mean anything to them, and they didn't value it as well as the species really needed them to value it. And then everybody that follows the listing decision basically has to comply. And it's costly and it's time consuming. And, all these projects they've had in the queue have a new bottom line that is dramatically different because of compliance costs. But this idea of the grand bargain, this idea of dedicating existing appropriations and existing programs to hyper-focus them to deliver recovery credits at big scales to make sure that, ranchers can keep on ranching, to make sure that the species, in this case, the lesser prairie chicken, has a shot at recovery, and then to make sure that there's no compliance hurdle to get in the way of the energy build out. I mean, I just think that's the way government should work. It should work to make our economy move more efficiently, and that includes the working lands as well as the energy developers. So we're excited to be a part of it. The conversations continue to advance, and I'm looking forward to providing everybody with an update here soon that hopefully, knock on wood, means that we're going to have some demonstration projects where the government is leveraging two separate departments, two separate programs, and the private sector to protect ranches for the benefit of the chicken in the long haul. And hopefully that leads us to a favorable listing outcome, which means energy development can happen without the threat of an endangered species listing. So I'm optimistic. Look forward to updating you again soon. If you want to help move the needle on this and you want to help advance the grand bargain, advance this idea of using government resources to keep species off the list and to allow the economy to just move at its own pace, I encourage you to reach out to your representatives, that's congressmen and senators, especially those that are on the agricultural committees. That would be huge. The Farm Bill, as many of you may know, last time it was passed was 2018. Doesn't look like this Congress is going to pass one. It might, but there might be what they call continuing resolution that provides additional funds for it. But they need to hear from their constituents that this is something that they think is exciting, that they would like to see, because without it, they're going to continue to do what they do, which is make investments where they kind of sort of can, and they'll spread that money all over the country. A little here, a little there, and no one species actually benefits. And the power issue that we're dealing with has a few hot spots. It's not like, I know that we talk about data centers everywhere, but the truth is the grid needs the most help in a few spots, one of which I'd say it's top 3, if not top 1, is in the Southern Great Plains. And that's where the real build out really needs to be hyper focused. And the lesser prairie chicken can get in the way of that if it becomes a compliance concern, and it can slow it down significantly. And we can lose part of this AI race, but more importantly, we could lose a species and a way of life, and that's ranching on the Southern Great Plains. So please reach out to your representative.